would like to. Okay, want to welcome everybody to today's webinar with the Business Incubator Association for New York State, and our guest today from the American Arbitration Association. For those of you who are just signing on and this is your first webinar with BIANYS, the Business Incubator Association of New York State was founded in 2006. At the time, it was 15 incubators that were brought together. They had never met each other, and they thought it would be a great introductory exercise. But by the end of the day, they realized there was a need for an organization, and they filed some bylaws with the state, established the association and an annual meeting. That has grown year over year. We're now at 120 members, both incubators and accelerators from across New York State that represent every industry, and some are specific to a specific industry like biotechnology or energy or fintech. And then others are agnostic to technology, but they're usually high-tech incubators. And then some are community incubators. So we really run the gamut in our membership. The 120 incubators and accelerators. When you look at all the companies they service every year, it's about 3,000 startups every year getting mentorship from our members. And BIANYS tries to pull together our members to give them great content like they're going to get today. And for those who are pinging even after we're live. So with that, this month's webinar is with the American Arbitration Association. We've been talking to them for a while now, because there is definitely a need in our membership, both incubator managers and then the clients that they serve, to get a better understanding of the arbitration process in general, and how that can benefit startup founders, and at the very least, just to understand the clauses that are in some of these contracts that we sign as entrepreneurs. So we're joined today by Jeff Zano and Angela Romero. And I'm going to flip it over to Jeff to do a broader introduction of himself and the organization.
Thanks so much, Mark, and be honest, and Mike, thank you. It's great to be here. Like Mark said, today we're going to give a general talk about arbitration. It's called "Do You Really Know What Arbitration Is?" I'm the commercial vice president based in New York City. My office is on 42nd Street, right across the street from the Chrysler Building. We hope to have one of your events at our office soon. I'm joined also by my colleague Angela Romero. Angela, you can give your introduction about what your background is.
Sure. So I am the vice president in the Miami office. I'm basically Jeff's counterpart down here in Miami, and I oversee the Southeast states. So from North Carolina south to Florida and including Puerto Rico.
Great. Thank you. Okay. I'm going to share my screen right now. Angela, just tell me if you see it.
Not yet, but it's loading. All right, there we go.
Okay. Let me do the slideshow. One second. Slideshow. Doesn't seem to be doing it. One second.
There you go.
Right. Are you seeing it as a wait? Hold on. Oh, pardon me.
There you go. From the beginning.
Yeah, the technology. Okay. So, like I said, this is a 101 on arbitration. Do you really know what arbitration is? We're first going to go over, about the AAA just briefly. We were formed in 1926, a year after the Arbitration Act, the Federal Arbitration Act in 1925. Like Mark mentioned, we are the biggest ADR provider in the world. We also do about 500,000 cases a year, a lot of business to business cases and a lot of small business cases. And we, like I said, do 500,000 cases. We have 28 offices and one in Singapore. Again, we started in 1926. Our initial caseload was labor. Since then, we've grown tremendously, and we do commercial, construction, insurance. We do educational programs. And one of the big things, our differences in comparison to other ADR providers, is we're a not-for-profit, and that makes us unique. And we'll go over that a little bit later on. Okay, the agenda today is we're going to give you a brief introduction. I'll start off with an introduction on dispute resolution, what it is, okay? We're not here to do a sales pitch for AAA. We're here to do a sales pitch for arbitration and mediation and the many, many benefits of it. So then We'll go into advantages of arbitration that Angela will talk about. We'll also talk about the disadvantages of arbitration. We're going to be honest here. There's some disadvantages too. So we're playing fair today. And then the advantages and disadvantages of litigation. Okay, and then the key takeaways, we'll close with that. So starting off with this introduction to ADR, I love this dispute resolution continuum. Mark or Mike, have you ever seen this before? No? Okay.
I don't think they have.
Okay, this is something that Angela and I use quite frequently when we speak to law firms. And we ask the lawyers to show their clients, okay, you as members should know about this. This is 8 areas of dispute resolution, okay? Starting off on the left, you have negotiation. And then all the way on the other end, you have litigation. You want to stay as a business on that left side, on negotiation. I always negotiate. I negotiate with my kids all the time. Okay, and it's an important thing is negotiation. You want to you want to avoid the dispute if you can. Okay, and you think that why would AAA say that? Because we make a business of resolving disputes through arbitration. Well, we're a not-for-profit. And we like to see our clients not end up in arbitration if they don't have to. So now if you move along this continuum, you start off with negotiation, then there's other techniques you can use. I'm going to go right up to mediation. Mediation is probably one of the most popular ones, and we'll talk about that in a few minutes. Then non-trial evaluative techniques, mock trial type, then arbitration and litigation. Now, as you go around this continuum, the costs go up big time, okay, really big time. And also as you go up, your power that you have over the process is reduced. And you don't want that. At the negotiation phase, you have all the power and all the authority. Even at mediation, you have a lot of authority because mediation is non-binding. You have a third-party mediator helping you, guiding you, and the person that you're having a dispute with. So again, these areas, you want to stay over to the left. And it's important to show the other side, this continuum. Again, we show this to lawyers all the time and say, you should definitely show your client at this and tell them the importance of staying over on the left side. But if you end up over on the right side, we're going to tell you why we think arbitration is probably the better way of going as opposed to litigation. Okay, so like I said, negotiation is so important. Disputants communicate their differences to one another. You know, we've all done it on this call. We've all negotiated before all throughout our life. Now, mediation, though, is different, okay? And a lot of people, even lawyers that Angela and I run across, don't know the difference between mediation and arbitration. And there are big differences, okay? And it's surprising, but then again, I'm in this world, so obviously Angela and I should know this world inside out, but a lot of lawyers are not necessarily mediating or arbitrating cases. But the differences are mediation, again, we bring in a neutral third party, and that person will sit with both sides, talk to them about their dispute, separate them, and do ex parte communication, which is allowed, and talk to them about their benefits of their case, the strengths and the weaknesses. And usually the person that's the mediator is an expert. We would not give you a mediator that does not know your business, your type of business, okay? So the mediator understands your business. It's not usually a former judge that may not understand like a construction dispute or an insurance dispute. So very important. And again, this is non-binding, okay? So you can get up and walk away at any point when you're mediating. So we always encourage people to try mediation no matter what, because at the end of the day, you can walk away. However, if you do come to some type of resolution and you're seeing that the other side's being reasonable, then at that session, the mediator will usually come out with a document and you sign it, and then that's binding. Okay, so just remember, mediation is a really great way of resolving disputes. Arbitration, on the other hand, is more like litigation, but it's litigation light, let's say. Okay, where you have an arbitrator that's sort of like a judge. He or she is an industry expert, okay, not a judge necessarily. We have former judges on our panel, and that person listens to the evidence on both sides, okay? There's witnesses, very much like a trial, but not, okay? It's informal. There's no rules of evidence. There's rules that we have at AAA, but you don't necessarily have to follow those rules if the parties are playing nice in the sandbox. And that's the cool thing about arbitration, the flexibility. So arbitration is different, but at the end of the day, the arbitrator will make a decision and render an award, and that's kind of like a judgment by a judge. Okay, so again, realize the differences between mediation and arbitration. Okay, Angela, I'm going to turn it over to you for the arbitration process.
Yes. So I do want to say one point about mediation, and that is that as you are counseling businesses, especially some of you that may be in very niche areas where you have these relationships that you may not be able to find anywhere else, mediation is a tool that will help you preserve those relationships. I think that once you start suing people, whether it's an arbitration or litigation, you may lose, you run the chance of losing some of these relationships. So I wanted to point that out. But how do you get to mediation and how do you get to arbitration, especially? So with negotiation, as Jeff says, it can happen at any time, right? Beginning, middle, end of the dispute. You don't really need to have anything in writing that says, let's try to negotiate a resolution. However, best practice, and sort of for you and anybody that you know that has a business that enters into any sort of transactions, is to have a contract. You need to put everything in writing. Otherwise, your recourse is very limited, especially if it involves, money, trade practices, anything in your business should be in writing. So I'm going to start off with that. Now, when you're putting a contract together, there's different provisions and different, payment plans and, whatever that relationship looks like. But there's a clause in your contract that talks about what happens if there is a dispute, right? What happens if the relationship goes sour, if someone doesn't pay or someone doesn't do what they're supposed to do. And so here's where, we come in and tell you, look at the different options that you have to put in a contract. And so what does that look like? Well, that looks like mediation, some sort of negotiation, and then arbitration. So Jeff,
Sure.
put up the standard resolution clause, and you can go to our website, adr.org, and you can find this clause that you can, copy and paste. We also have a tool, and I'll mention it real quick. It's called clausebuilder.org. And when it's Jeff's turn to talk, I'll drop that in the chat box so that everybody has it. But essentially what this does is this clause gives you the opportunity to manage how you're going to resolve that dispute. So this is a standard clause. This is a valid standard clause. So I want to make sure you understand that you can go to court with this and the court will say this is valid. So any controversy or claim arising out of or relating to this contract is going to be settled by mediation. As I said, mediation should be your first step. Really think about it. Obviously, negotiation is always there, but a more formal mediation should always be the first step. And then the second is, what happens if you don't resolve it at mediation? You can go to litigation, and we'll talk a little bit about that, later on in our conversation, but you really should consider arbitration.
Angela, do you want me to turn
Yes.
to the next slide?
Yes.
Oh, I'm sorry. Okay. Sorry. Oh, can I just interrupt for 1 second? You made a great point about, when people are negotiating a contract, they don't want to talk about if a dispute occurs. And that's the last thing they want to talk about. It's like when you're getting married, you don't want to talk about, what's going to happen if we get a divorce, but you have to, and just realize that. And a lot of people say, I don't want to talk, I don't want to bring it up. Tell your attorney he or she has to bring it up. So sorry,
Yeah.
Angela.
No, that's fine. That's actually a good point. When you are negotiating some of the terms on your contracts, I think the last thing that you always think about is, it's what's a dispute, right? Like if it's going to happen, because you are in a great state in your, relationship with your other partner, whether it's, as a business or with your suppliers or vendors, whoever, and you're like, oh, this is going to go great. And, nothing's going to happen. Well, you have to account for what if this happens. So think of an arbitration clause as an insurance policy. Yep. So what do you think about when you are drafting an arbitration clause? And like I said, I'll drop in the clause builder information, but these are some of the key points that we always recommend your contract should have. So your dispute resolution provision, number 12 in your contract, whatever. So you want to start with mediation. You want to put a deadline for when that mediation is going to take place. You don't want mediation to be lingering forever. You want to look at, what law you should include in your contract what is going to be, if you need to enforce a contract. So what type of law is it? Is it like New York law? Is it Florida law? You know, where are your clients? Where do you think will work best for all of you? The locale is the same situation, right? You know, so if you're in New York, you want to maybe have New York locale, but what if there's another locale that is better for your business, and for your clients? Arbitrator selection. So there are a ton of ways to select an arbitrator. Our commercial rules have a default process. And so if you don't include how that arbitrator is going to be selected, what the number of arbitrators is going to be, our rules will fill in those blanks. And so that's kind of like number 7, arbitration rules. As Jeff mentioned before, you know, we started with labor, but we have commercial rules, employment rules, international rules. So look at all of these different options that you have and see what will work best for your business. If you're running a construction company, you may want to use the construction rules. You know, what if you're running a hospital? We have payer provider rules specifically for healthcare disputes. Confidentiality, and I'll talk a little bit about this. I'll go in depth with this. So everybody thinks arbitration is confidential. Well, kind of, sort of. So for the AAA, in our rules, in the commercial rules, it says that arbitration is confidential for the AAA and for the arbitrator, but it doesn't mention the parties. Now, it is a private process, and I saw Mark going, yes, because everybody thinks that arbitration is confidential by default. It's kind of not. So you have to put it in your contract that the case or that the arbitration is going to be confidential. Why? Because that is one of the benefits of arbitration. We can comply with your request for confidentiality, and so does the arbitrator, and so does the other parties.
And then, Angela, sometimes people say, well, when you do put a confidentiality clause or that the process is private, that you're in a star chamber, and that's not true. Okay, arbitration, we have code of ethics for our arbitrators. For AAA, we are confidential. The AAA also are arbitrators. But if you don't put that confidentiality clause in there, one side can talk to the public, and we've seen that happen. And
Yes.
so, but don't let people tell you that, oh, it's a star chamber and it's a hidden process. It's not in the public eye. Well, a lot of people want it confidential because of trade secrets. Like we deal with Microsoft, and I can say that because some of their cases go to court. They don't want their trade secrets out there, so they want the process confidential and private. So sorry, Andrew.
No, you're fine. So yeah, I mean, if some of you, as Mark said, if you're in the, you know, biotech energy, you know, you don't necessarily want your competitors knowing what you're doing and how you're doing it. So think about including that confidentiality clause. Also, you could have not included confidentiality in your contract, and then when you come to arbitration, you can agree, like post dispute, to have the arbitrator include confidentiality as an order. But do you really want to wait until that happens and maybe the other party already filed something at court, including all this information? I don't think so.
No.
So as Jeff mentioned, arbitration shouldn't really be litigation light, and that's number 6 in discovery. So our rules do provide for some exchange information. And so you should consider what you really want that arbitration to look like in terms of exchanging information from both sides. This can get as complicated as litigation, and we'll talk about that, meaning you can have your regular rules of civil procedure, the rules that govern your courts, and have all this sort of discovery and spend as much money or even more than you would if you went to litigation? Or do you really want to use the process as it was intended? And so that is number 6. And then number 7 kind of correlates to everything else. And I just mentioned, you know, our industry rules. And number 8, attorney's fees and costs. So listen, if you are an attorney or if you are working with an attorney, they need to get paid. If they file a lawsuit, how are they going to get paid? You know, that can also be included in the contract. Like if you lose, or if the prevailing party is usually the language is, if someone wins, then they recover the attorney's fees and costs. And then the award type. So what is an award? An award is basically the judge's rule, the arbitrator's determination. So it's the same as the judge's ruling. That's what I wanted to say. So there are different types of award. A simple award that basically says you win, XYZ loses. There's something a little bit more that adds a little bit more of a reason. It's called a reasoned award. And then something that is more it's usually left for very complicated, large cases, which is findings of facts and conclusions of law. So everything has a cost. So, you know, obviously think about it when you're looking at some of these provisions. But I'll turn it over to Jeff.
And if you, just to close out on that, if you agree to arbitration and you want an arbitration clause in your contract, and you're missing some of these items that Angela is talking about, specifically maybe locale or the amount of arbitrators, things like that, you could end up in court. And you don't want that, okay? So, and also you can end up in court if you don't put an ADR provider in there, okay? And we're not saying put the AAA necessarily. You put any ADR provider in there. We prefer if you put AAA, but if you don't put an ADR provider in there, it could potentially end up as an ad hoc arbitration. And ad hoc arbitrations, that means it's done without an institution. If there's a problem, if you're missing something on the clause or some kind of ethical problem occurs or something with the arbitrator occurs, you end up in court. Not necessarily if you have an ADR provider helping you out with that. So let me take.
Before you go to the next slide, if I can, I just want to ask a question.
Sure.
You know, just to frame all of this, my understanding is the benefits of arbitration, I know we're going to get to all of them, is that time and cost are mitigated in resolving disputes you have with somebody you have a contract with. So if you have an arbitration clause in your contract, you know, especially as a startup, you can save yourself a lot of heartache and a lot of money and a lot of lost time in resolving it quickly. And this slide is kind of a roadmap where if we're going to try to make sure that this is in our agreements, we should have a picture of this slide next to, you know, the agreement that's being drafted to make sure all of this is spelt out in the agreement.
That's right.
We really want to maximize the benefits of arbitration.
Without a doubt.
And I just, right, that's right. And I just put in the chat clausebuilder.org. So that is a free tool. So just go in clausebuilder.org.
It's our most hit site. It's not
yes,
cool.
It'll ask you questions. It'll say, do you want mediation? What type of law do you want? Where do you want the arbitration to take place? How many arbitrators do you want? Do you want to add confidentiality? So to ask you all these questions to all of the points that we mentioned today. So you can say yes, no, 1 arbitrator, 3 arbitrators, yes, confidentiality, no to attorney's fees and costs. Yes, we want remedies for X, Y, Z. So you're able to tailor that contract to meet your goals of efficiency and, you know, cost savings.
Absolutely. And also Clause Builder, in addition to giving you all the areas that you should put in there, we give a paragraph saying why we think that should be in the contract. And like I said, it's the most hit site and it's free, like Angela mentioned. Check it out. Or if your attorney's not using, that's shocking. When I go to law firms and I know there's transactional attorneys that never even heard of Clause Builder, I'm a little bit taken aback by that because it's such an easy tool to use. I highly recommend it. Check it out. It's kind of cool. Okay, the arbitration process. Arbitration usually takes anywhere between, I would say, 9 months, maybe 6 months to 9 months. Some of the smaller cases, maybe a few months. But a standard case, I'm going to go over, you know, the filing and initiation. There's a cost associated with it, obviously, but it's very transparent at AAA ICDR. It's a sliding scale fee based on the amount of your claim. If you go onto our website, you can see the sliding scale for fees, okay? And that's usually the initial part someone will file with our intake department. You can do this all online. That's what's so cool about it nowadays. I remember the days I've been around long enough at AAA when everything was done by fax or paper or whatever. Now it's all done electronically. Your attorney can pay by credit card now. It's really easy. And at that point, you're asserting your claim, and then the other side is notified about your initiation of the case. Okay, then days 15 to 44, once the case has been perfected and AAA is reviewing the case, at that point, we're going to talk to you, okay? We're going to talk to the parties and ask them, okay, what type of arbitrator are you looking for? And that's what's kind of cool about this process. That doesn't happen in court. Okay, you're going to get an arbitrator based on a rotation basis, okay? And your attorney may not like that judge. Okay, and you may be stuck with a judge that can be a difficult judge. So in this start of the process, we will ask you what type of arbitrator you're looking for. Then AAA will, the default method is producing a list. Okay, for a panel of 3, we'd produce a list of 15. For just one arbitrator, we'd give you 10 names, and we give you a nice resume. okay, of the arbitrator. And a lot of our arbitrators now have a little video. You hit the video and you can see a 2-minute video of that arbitrator, a little vignette, which is kind of cool because you can get a feel for your arbitrator. So I highly recommend, if you do have an arbitration case, that you ask your attorney to, you want to see the video, okay? You also see on their resume how much they're going to cost, their hourly rate, their background, their education, all that kind of stuff, their whole history. It's usually, these resumes are anywhere between 2 to 5 pages long. But that, again, is the default method. Parties can also come to the table, and Angela and I see this where they already have an arbitrator selected. You can select anybody at the AAA ICDR, I mean, outside of the AAA ICDR, to hear your case. If there's a person that you know in the industry that's an expert, you can select that person to hear your case if both sides agree. Okay, so that's a method. You can also be creative on how you select an arbitrator. So once the arbitrator is selected, then the arbitrator will have a preliminary hearing. And that's a good time for you to meet with the arbitrator, okay, and discuss how long is this case going to take? How much is it going to cost? All that kind of stuff. That's what you go over in that call. And a lot of times at the prelim hearing, you can narrow some of the issues of your case and potentially even settle the case. So that's an important part of the process. Okay, information exchange. Okay, but this is discovery. Okay, and this is where this is day 85 to 222 approximately. Okay, and this is when you're exchanging information with the other side. And a lot of times you don't have to get the arbitrator involved with the exchange of information, but then you want the arbitrator to review these documents, and then you'll submit these to the arbitrator, and the arbitrator will review them. And then again, this is all informal. A lot of it's done on uploading documents to a system that we have at AAA, or via email. Not true in the court system, a lot different. Okay, it's a lot more formal. This is a very informal process, and the you're not going to call the arbitrators your honor or whatever, anything like that. It's a different kind of process.
I will say, Jeff, let me interrupt you for a
Sure.
second. I will
Absolutely.
say a couple things about this. So number one is these timelines are set for cases that are $500,000 or more.
Great point.
But we have different types of procedures depending on the amount that is being disputed. So if you have cases that are $100,000 or less, your timeline is going to look a lot different. For those cases, our hope is that they're finished within 3 months. I had someone on the phone actually say to me, "Oh, do you think that's fast?" And I'm like, "Well, try your luck at court and see if you can resolve $100,000 in 3 months. If you can, please call me and let me know." With an expert, because that's, going back to Jeff's point, your arbitrator selection is important because you're selecting who you have a say as to who is deciding your case. So I just want you to keep that in mind, that these timelines are for cases that are $500,000 or more. We have an expedited track for cases that are $100,000 or less. We have an even shorter track for cases that are $25,000 or less. Those cases are usually decided just based on documents, meaning that each party will submit to the arbitrator writings supporting their positions, and the arbitrator will render a decision. And I will say about the decision, and Jeff will talk about it in a second, is that when you go to court, how long does it take for a judge to make a decision on anything? In arbitration, the case administrators at the AAA were always paying attention to how long these arbitrators are taking in making rulings, because in this information exchange, there may be disagreements between both sides as to what is being exchanged. In court, you would have to file a motion with the court, you would have to get a hearing in front of the judge, and you would have to wait for the judge to decide. The judge may or may not decide it at that same time. In arbitration, you can send an email and say, "This is my disagreement, can we get on a call today?" And you would get on a call, in a very short amount of time with that arbitrator, and that arbitrator may render a decision on the spot, or usually within a very, very, very short amount of time. And so that's kind of like a benefit also of having the AAA involved, is that the case administrators are making sure that these things are happening in a very short time frame. Jeff?
Great. And sophisticated attorneys understand arbitration nowadays. It's growing tremendously. So if you have an attorney that has done arbitrations, he or she is going to know how to not work the system, but work through the system and make it more efficient. Okay. And that's really important to make sure that your attorney does understand arbitration or appreciates it. And most attorneys do nowadays because it's becoming such a big thing. When I started at AAA in the 90s, we were at 1 million cases. Okay. And then from the early 90s until now, we're at 8 million. This shows you, this is just AAA. This shows you how much arbitration is growing in the country. So really important to make sure your attorney understands arbitration. The final hearing, and actually one other point I forgot to mention, like Angela mentioned, some of the small cases can be done on documents only. I love to see that, where you don't have to go to an in-person hearing, and a lot of them are done via Zoom anyways. However, we just acquired a company called ODR, Online Dispute Resolution, and we're looking at doing a lot of things online now, especially for smaller entities, okay? And we're calling it access to justice, where some people could not afford to go to court. Now they can do it online, and that's something that, stay tuned. That's what we're doing in the near future. Final hearing. Okay, this is where the arbitrator will render a decision. Okay, and like Angela mentioned, there's these that are sometimes there's a reasoned decision, sometimes there's not. Most cases are reasoned. Okay, and then the arbitrator has to be compensated for his or her time, and we at AAA collect the money and issue the money, but we make sure that the arbitrator make sure that he or she gives us a detailed invoice on what they spent on the case. And that's part of our role, is to monitor how much the arbitrator is spending on the case, okay? And our arbitrators they're bound by guidelines, code of ethics, guidelines for billing, and all that kind of fun stuff. Okay, post-hearing submissions, this is what you can do, after the arbitrator is compensated for reviewing evidence, and any unused deposits are returned to the party. It's really important. We don't keep the money. We ask for deposits up front, and we'll say, okay, this case is going to cost such and such for A to Z. We'll collect the money from both sides, and we'll have the arbitrator bill us, and whatever is left over goes back to the parties. It's split between the parties. Okay, the award, I kind of already mentioned it a few minutes ago. Maybe I jumped a slide, but the arbitrator will decide how the apportionment of the fees are going to be. Okay, you can make your arguments on that, and then again, the AAA will return the deposits that have not been used in the case. Okay, advantages and disadvantages to arbitration. I'll turn it over to Angela.
All right, thanks, Steph. So we've mentioned several of these, so I'll just go over them real quick. So faster. Yes, as I said, there are things that can be done a lot faster in arbitration. Everything is also going to depend on what jurisdiction you're in. I had a conversation with an attorney once. I think they were in Tennessee, and, I said, you don't use arbitration? Like, no, our judges here handle things. We trust our judges. They run through things pretty quickly. I can't say the same thing about Florida. I mean, I can't say the same thing maybe about New York. Like your dockets may be way, way, way behind. And so, an alternative to that is arbitration, because it's faster, because you can get to your decision maker in a lot quicker than you would if you have to go, through the legal system, through the litigation.
And also, during the pandemic, all the court systems shut down. We never shut down, the ADR providers around the world. And we started getting cases from the court system, and they were backlogged, obviously, during the pandemic, and they're still backlogged to this day, even though the pandemic's been over for a few years.
Yeah. It can also be less expensive. The biggest criticism that we hear all the time is that arbitration can be expensive. Listen, it is as expensive as you and your attorney make it to be honest. If you comply with our rules, if you follow the rules, and if you don't engage in a lot of discovery, if you don't turn it into litigation, it can be less expensive than court. It becomes more expensive when you want to do the same thing that you would in front of a judge to the arbitrator, or with the arbitrator.
And the cost on that, Angela and I went over this yesterday. We were talking about this program. 5% of the cost are for filing the fee with AAA. Then 10% is the arbitrator's cost. The rest of it is your attorneys. So, like Angela said, if you can keep your control over your attorneys, then the process is not that expensive. Really, it's not. 5%
And
us.
you start that control, as we mentioned, in the arbitration clause.
Yep.
So everything kind of ties back together. We already talked a little bit about confidentiality, so I'm not going to repeat that. Arbitrator selection, I think you understand if you are in a very niche area, you know, again, I always refer to, you know, biotech. We have a life sciences sector where we have arbitrators that we've vetted, you know, that have the biotech experience, the pharma experience. You know, we require arbitrators in commercial cases a minimum of 15 years of experience. If they're in construction, 50% of the practice has to be in construction. So you're not just getting a random assigned person, you have a say as to who is going to make decisions in your case. That goes along with expertise. Also, you know, the AAA has its own expertise. I mean, we've been around for almost 100 years. Our case administrators go through trainings all the time. Jeff and I serve as case administrators on high value cases. So you get high touch sometimes from VPs that have been around for a very long time that understand how to keep the cases moving. It is flexible, meaning everything takes into account what your schedule looks like. We want parties to work together on, maybe you don't want 5 days of hearing. Maybe you want 1 day and you want to submit things to the arbitrator so that the arbitrator reviews them. Maybe parties cannot all be in person and you do things by Zoom or by Teams or whatever. So you make the process work for your case. Again, when you're looking at industry rules that we have, that also creates flexibility for you. And then final and binding. So what does that mean? Once that arbitrator renders that final award, that's it. The case is over. We're done. That is an advantage. And, you know, Jeff will talk, or I'll talk about a disadvantage of arbitration, because that is also a disadvantage depending on who you are, right? If you win, it's final, you're done. You have an arbitration award that you can confirm and turn it into a judgment if you need to. If you lost, it's final. And then it's hard for you to kind of like overturn that award. There's very few reasons why awards are overturned. There can be challenges to award. It happens often, but courts won't review the award again to see if the arbitrator made a mistake or not. The reasons for challenging awards are very limited.
Sure.
Next
now,
slide.
on the final and binding thing, if you do want an appellate process, we do offer it, but we have optional appellate rules that were drafted in 2013, a little controversial internally. We weren't sure if we should do it, but that's only for really high-end dollar cases. And we only see, I think, Angela, about 5 cases a year, if that, out of the 500,000.
I think I've only had one.
Yeah. So, but because arbitration is normally deemed final and binding, that's why people like it. And like Angela said, it's really hard to vacate, overturn an award. And then I just wanted to go back to arbitrator selection, just to quickly mention diversity. You know, we do care about diversity at AAA. Our lists that go out are a minimum of 30% diverse. And usually, Angela, what is it, like 34%, if not a little bit higher, I think,
Yes.
somewhere around there. Yeah, so that's something that we care about at AAA, and we meet that 30% threshold at the AAA ICDR.
Yeah. So with disadvantages of arbitration, I already mentioned final and binding. It really depends on which side you are. It is less formal. So I will say that there are some people that are uncomfortable with that. Some people don't want to be creative. And some people prefer the court rules. I had an attorney that said that to me once, you know, I hate arbitration because it's, you know, it's the wild, wild west. It's not. It's just that he just wasn't creative enough to make it work.
And Angela, have you had people, clients that have said, I've heard this, where they said, I lost one arbitration, I will never go to arbitration again. My response to them is, have you ever lost a litigation? And the answer is usually, yeah, I've lost many. So people can't give arbitration a bad name just because they lose one case. Maybe they argued it poorly. Maybe the arbitrator didn't understand the facts or whatever. But you know, there's a lot of reasons for losing a case.
Yeah. A disadvantage of arbitration is limited discovery. You know, as we mentioned, the goal of arbitration is that you're getting to a resolution that is faster, that the process is more efficient for you and more cost effective. But you know, if you have an attorney that only knows litigation, then the limited discovery will put them off, right? It will be a disadvantage for them. It can be costly. Why? Because then you go and you litigate the hell out of that case, and then that's going to cost you some money. Enforcement. I will talk a little bit about enforcement because someone was asking me these questions today. It's like, what do I do if, the other side doesn't comply? So we want arbitration to be a one-stop shop, but it doesn't happen like that all the time. And so what happens is once that award has been rendered, we are done. The jurisdiction of the AAA is done. And so if the other side, if the losing side doesn't do what they're supposed to do, what the award says that they're supposed to do, you do have to go to court. And so the disadvantage is that a lot of our awards are complied with voluntarily, but some people just don't. And so now you have to kind of start, a court process to get that award enforced. And then no precedent. So for some of you lawyers or your lawyers, they may want to take that one case and apply it to all of the other disputes that they may have. And so in arbitration, because it is confidential and private, you can't use the award from one arbitrator and go to another arbitration and say, hey, this arbitrator said this and that and the other, and you need to follow what this arbitrator said in this case. It doesn't work like that in arbitration.
Now, why there's two areas that people dislike arbitration, and you'll hear this, you probably have already heard it. The two areas, not what you're in, B2B, because those contracts that you would enter into, business to business, but it's employment and consumer. And why is that? Well, those two areas, people call it a contract of adhesion, where you're forced into signing a contract. So you go to get your cell phone. I have my cell phone right here. Go to get my cell phone at AT&T, and there's a clause in there that says you got to go to AAA if there's a dispute. You got to go to arbitration. And you're like, well, I'm going to cross that off. Okay. Well, they're not going to give you your phone then. Okay. So you're forced into signing that contract. Also with employment, you go to get a job and you're all excited about this job, and there's an employment clause that says you have to go to arbitration at the AAA or GM's or whatever provider. And you say, I don't want to sign that. Well, you're not going to get the job. Okay, so that's why people get angry about arbitration. But I'm here to say that we, the AAA and the other ADR providers, are the good guys. And what do I mean by that? Well, we don't draft ourselves into contracts. Okay, people draft us into millions and millions of contracts every year. Okay, they never even talk to us about it. Okay, but what we do at AAA for those two areas, we have a due process protocol. Okay, and that due process protocol levels the playing field. Okay, and what do I mean by that? That means that in the past, with consumer disputes and employment disputes, the companies would control. Okay, and they would say, well, we're going to select this type of arbitrator. The employee would not have a say over it. We're going to limit discovery. Not the case with our due process protocol. It levels the playing field. It lets the employee, it lets the consumer have a say in this process. Also, the consumer and the employee don't pay the fees. They pay a minimal fee, and then the companies pay the bulk of the fees. So you'll hear time and time again that arbitration is bad, but it's just because of those two areas. And you'll hear members of Congress every couple of years, there's proposals in Congress to end employment and consumer or pre-dispute arbitration clauses. At AAA, we if it happens, it happens. But our core business is business to business. Okay, and that's what we care about the most. But if we're going to get these cases, we're going to try to help out and make sure that it's fair. Okay, so turning to the advantages and disadvantages of litigation. Advantages of litigation. Okay, like Angela mentioned, there's an appellate process in all litigation that exists. You don't have to draft it into a contract like you would with arbitration. Enforcement, it's much easier in litigation for enforcement. Okay, people feel it's a traditional process. Okay, they like that. Okay, a lot of times we see people coming into AAA in Miami and in New York, and they treat arbitration like litigation because they're just so used to it. I even had people come to my hearing rooms in Manhattan and set it up like a courtroom. Okay, even though arbitration shouldn't be that way, it should just be a conference room table, very informal, but people are used to that traditional feeling of the court. Precedent, Angela mentioned that. There's precedent in court. Your lawyer can look at past decisions and base his or her decision, or base his or her arguments on that precedent. And then there's various remedies, and then it's public record. Okay, but like I mentioned about the public record, it's a public forum, but a lot of times you may not want things to be public. And even I'll give you an example about private and confidentiality. We have a lot of high-profile cases where we have famous people that come through our office, actors and actresses and musicians and rap stars and people that everyone on this call would know. They love the fact that this process is not public, and it's not, they don't go to the courthouse and there's photographers there. And I had a case in my office about a couple of years ago. As an actress that everyone on this call would know, she was able to walk around freely around my office because no one was going to bother her. If she was in the courthouse in New York City, page 6 of the New York Post would have a picture of her. So that's but again, I was supposed to be talking about the advantages, and I kind of talked about so the disadvantages. See, I've been too brainwashed on arbitration. Disadvantages: time consuming, and I'm being conservative here. Usually 2 years, 3 years for a complicated or even a less complicated matter in court takes a long time. It really does. And it's expensive. And like Angela mentioned, okay, yeah, you got to file, you have filing fees at AAA, but it's not us. It's really the litigators. And a lot of people say, well, I have to pay for my arbitrator. Yeah, you do, but the case is going to end much faster. Okay, adversarial. The system is set up. When Angela and I went to law school, there was like the moot court competitions and things like that. You're trained as a lawyer to argue. Okay, and arbitration is not that way. Okay, arbitration is more the arbitrator controls it. It's not as adversarial. Public, I mentioned that there's disadvantages to being public. A lot of people don't like their stuff, that they air their dirty laundry. Okay, limited control. We mentioned this at the beginning. If you get up to litigation, you have no control. Now, if any of you on this call has been through a court process, it is brutal. When you get assigned a judge, I had a court process years ago where the judge, one of the judges retired, then another judge came in, and then another judge came in after that. And it was 3 judges, and we had to educate that judge each time. And then also, and he or she controls the process. It drives me crazy. Lack of expertise. Okay, you don't want to sit there educating the arbitrator about your specific business. And we see this a lot with the construction disputes, where we have a construction contractor does not want to judge because he or she's going to have to educate them on, how to, about engineering, architecture, and all that kind of stuff that you just don't want, a judge. You have to educate the judge. And then
we also see that, we also see that in our tech disputes. We also see that on our healthcare and our biotech, because those are they're very, very specific areas where a judge that just went from county court, traffic court to your circuit court you may not want that person adjudicating your case. Absolutely.
And like Angela mentioned, other areas beyond construction, I see it in commercial, but I think, correct me if I'm wrong, Angela, 95% of our arbitrators are lawyers. But is that correct? Yeah, I think it's 95%. But they're experts in the field. They've been doing construction law for their whole career. They've been doing, insurance law. But if you want an industry professional, if you want someone that is actually an accountant or actually an architect or an engineer, you can get that at the AAA. We have people like that. So there's non-attorneys that are arbitrators on our cases, but the bulk of them are lawyers, but they really do understand the industry. And then the final disadvantage of litigation is the appeals process. Giving the other side a bite at the apple again, and it's going to cost you a lot of money. That's not a good thing. You may not want that. Some clients do, but some clients don't. So these are the disadvantages. I think the biggest one on this list here, I think it's time consuming and cost. Those are the 2 areas about that are litigation. And we did a study. And if you look it up, Google it, micronomics and arbitration, just type in micronomics and arbitration. We studied comparing arbitration cases that were actually done at the AAA with litigation, actual cases done litigation. And I'm not smart enough to remember the numbers, but the numbers were astronomical in the cost differences. And the time factor was huge. So take a look at that study if you're ready to file an arbitration or considering arbitration or litigation. That report will scare you. It really will scare you. So definitely something to take a look at. Okay, so the key takeaways.
So to that end, I'm just going to make a comment. Oftentimes I'm told by attorneys, when you have a dispute, when you're thinking about the cost of litigation, if the dispute is not over $100,000, don't even think about, filing a cause of action, because or actually sometimes it's $300,000, because the cause going through the litigation will cost easily over $100,000 in legal costs. and you're still rolling the dice on whether or not you could actually win in court. So especially if you're having contracts that are less than that and you want to
Sure.
make them enforceable, I guess you have to be looking at arbitration. You know, because those contracts probably cost a whole lot less to arbitrate.
Yeah,
Absolutely.
and that goes to pay attention to the clause, right? And then when we talked about drafting clauses, you can put in that disputes that are $100,000 or less, you're going to go to court, and $100,000 or more, you're going to go to arbitration. You can always make changes and adjustments. And this is kind of like the benefit of arbitration is that it's flexible. And when
Right.
you are negotiating that contract with the other party, because again, we're talking business to business relationships, you can both say, you know what, I think it's going to cost us a lot less if we go to small claims court. You know, for example,
Right.
someone was calling me today and we were talking about a $12,000 dispute. When I started adding the numbers and even telling them how much it's going to cost, it may not make sense to use our services. And we're
Right.
honest about that. We might as well say, you know what, I think maybe you should kind of carve this out of your clause moving forward, where you say, you know, if a dispute is, you know, $15,000 or $25,000 or whatever, those are going to go to small claim court and everything else is going to go to arbitration. But also keep in mind that it may be a small dispute, $25,000 dispute, but what does it involve? What type of issues are going to have to be addressed? Because again, if you are in a very technical industry where it may be a small issue or small amount, but the issues may be also complicated, where you still may want an arbitrator for those.
Got it.
Well, you're so right about the cost. I mean, sometimes cases may not be a good fit for arbitration because of the cost. But what we do, you know, like, but if you carve out, or if you not carve out, you properly draft a clause, you can avoid some of those costs. But also at the beginning of a case, after the preliminary hearing, we talk to the arbitrator or arbitrators and get what this process is going to cost. And then we tell you right up front. We tell you right before the first hearing. And a lot of times that causes the parties to settle. They'll say, oh, wow, they get a sticker shock and they get a bill. And they say, oh, I don't want to pay for this whole process. Or I want to, you know, figure out some other way to resolve this process. So we do give you upfront, everything's transparent, not in court. You can go down the rabbit hole in court. You can be in court and all of a sudden it starts consuming money and you're in trouble. But now just in the final minutes, the key takeaways, we already mentioned, paying attention to the clause, so important. I think on this list, and I think we talked about it a little bit, mediation should be on this list, and always consider mediation. And I know I talked about it, I think Angela did too, but it's such an important part because if you don't resolve the dispute in mediation, you may be able to narrow the issues. And Angela mentioned when she's talking about the clauses, put in a mediation part, a step clause. Okay, so start with mediation and then go into arbitration. So Angela, do you want to take some of these other ones?
Yeah, sure. So I think we talked about, choosing the right arbitrator, but I'm going to kind of make another point as to what Jeff said earlier, which is shop around for your lawyers. A lot of people think that once they sit down with one attorney, that has to be the attorney. No, ask them if they have experience in arbitration. Ask them if they have experience with the AAA or any other organization, because the arbitrator attorney is different than a litigator attorney. They will understand how to keep costs down, how to make the process more effective, how to make the process more efficient. They're not going to, want to delay. So select experienced lawyers. I said it, I'll say it's like a key takeaway from here. Remain open to settlement. Again, going back to mediation and arbitration. Yes, we are the American Arbitration Association, but we really want the parties to resolve the issues amongst themselves. We want you to retain control over your decision making, which gets taken away once that arbitrator issues that award. We've seen cases settle while the hearing is going. I had a case last year that it was the second day of the evidentiary hearings. And what happened? The parties hadn't seen each other. They hadn't really talked to each other. And they realized once they saw the 10 lawyers in the room, and I'm sure they started counting the lawyers, counting the time that they're charging per hour, counting the 3-member panel. And they said, let's balance this out. Let's sit down with each other. Let's talk about a settlement. And the case actually settled the second day of arbitration.
Right.
Jeff?
Sure. Okay, so we covered a lot of this, but the key take with limit discovery, very important. Participate in the prelim hearing. We see during the pandemic, I'm not sure, Angela, if this is the same for you. I started to see a lot of the clients showing up on the preliminary hearing. Usually it's just the attorneys, your attorney, but you as a business owner, you should be on that call. It's so important so you can see what's going to occur. Also, remain open to settlement. So important that you stay focused on settling at any point during the case, and we'll help you. Trust the expertise of the arbitrator. They should know it. Your attorney is responsible for making sure you get the right arbitrator in this case, and make sure your arbitrator presents it efficiently. Really effectively too. It's so important. But a couple other things. I just want to make sure that you understand also the difference in closing, the difference between a not-for-profit ADR provider and a profit-based ADR provider. And I'm not going to slam our competitors. There's some other not-for-profit ADR providers like us, but the difference is the cost. Okay, and also the fact that the arbitrators in some of these private-based institutions, they are actually shareholders of the institution. Okay, and that's not a good thing. Our arbitrators are completely independent. We can remove them at any point. Some of these other institutions, their arbitrators get money based on what the company's making too. So the longer the case goes, the longer that institution's going to, and the more money that institution's going to make. Not true with AAA. Our arbitrators decide their own fee. They get 100% of whatever fee they bill. Also, we have upfront fees at AAA, okay, and it's all transparent. So there's a big difference. Just make sure your clients know that. I mean, your attorneys know that too, because I was at a law firm a couple of weeks ago, and they didn't understand the difference between a profit-based ADR provider and a not-for-profit-based arbitrator. So
And
big difference.
I will make one last point so I can give 3 minutes
Yeah.
back to you, is make sure that when you are including a clause, that you don't leave out an organization, because you can do this on your own. You can call your neighbor and say, hey, arbitrate this for me. But there's a lot of fail safes that are put in place when you're using an organization that's administering the arbitration, like the AAA.
And we're not Andrew Barton. I'm Jeff Zano and Angelo Romero. Andrew actually put the slide deck together for us. So he put his name on there. We should put our names on there. But also, please feel free at any point. We're collaborating with you. But even if we weren't collaborating with you, your organization, you can contact us. A lot of attorneys don't think they can contact us directly. That'd be calling me up or calling Angela up if you have a question about an arbitrator or a mediator. I get those calls, occasionally, but more people should be calling me. And also, if you're drafting a clause, also if you have a problem in a case, even if it's a pending case at AAA, you can call us. And we're not going to talk about the specifics of the case, but we'll talk in general about what we've seen and whether or not this arbitrator is the right arbitrator for this case. So feel free to use this as a resource. So Mark and Mike, if there's any final questions, I know we have like a minute.
You actually answered a lot of my questions that I wrote down in the beginning of the presentation, that means it's a really good presentation because you kind of covered where questions would pop. And I'm going to hold off on my last question just in case any of our members that have joined the call have any, because I don't want to eat up all the air time. Does anybody have any questions or comments? All right, so if nobody is raising their hand, mine was, and you might have mentioned this, so excuse me, but I did not get it as my takeaway, is the enforcement piece. So I go through arbitration, I win an award, they don't pay, and I know in court, I take that judgment, I file it, I could go to the sheriff, and so how does it work with arbitration? Like if I have somebody that I beat and I have an award and they won't pay?
So the process is the same, in the sense that you would go to court, but you don't have a judgment, you have an award. So you have to go to court, get the judgment, get the award confirmed and turned into a judgment. And then at that point, it would be where you would, go to the sheriff and say.
They can't really dispute the facts there. It's just, hey, you
Correct.
have.
That's correct.
It's right. Pro forma. Okay.
Yeah, and the only problem is then it becomes public record, and a lot. If you want this process to be private and confidential, then things become public. I mean, you can ask it to be under seal, but usually the judge is not going to allow that.
Sure.
But we don't see. I mean, a lot of people don't challenge awards. We don't see a lot of those problems. We don't hear about a lot of it, but I don't see a lot of that happening.
I think I was doing a presentation on awards recently, and I think the statistics is like, I think maybe 5% of award challenges are upheld. I mean, that's a very small amount. Don't quote me on it, but I think that's what I saw. So I think it's about 5% that are upheld. So however many are filed each year, 5% is a very small amount.
Angela, you're
Because
being
it takes a lot. They're not going to review necessarily what the arbitrator did or didn't do. They're looking at whether the arbitrator committed fraud, whether they didn't disclose something that they had to disclose. You know, I said this at a recent presentation. Was the arbitrator drunk the entire time? I mean, like, it has to be something so egregious.
Right.
The standard is so high.
It's so high.
Yeah, and we've seen more people filing for it, but the same amount of cases are being vacated since, like, I've been doing this for, you know, over 20 years. So it hasn't increased.
Yep.
But Mark, thank you.
Okay.
And Mike, thank you. You know, it was an honor and pleasure working with you on this.
So likewise, we're right on time, and I know that this is the beginning of an education process for our membership. So I hope that we do something very similar again, hopefully in person at your offices.
That would be great.
That'd be
And
awesome.
really appreciate the opportunity. So thanks
Thank
so
you,
much for your
Mark
time.
and Mike, and thanks everybody that joined.
Yep,
If you have
thanks
any
for doing it.
questions, just reach out to us.
Great. Thanks, guys. Bye-bye.
Okay.
Take care.